Then start writing. Openness, hearing has to be open for everyone. Anyone can go and attend hearing. Hearing has to be open, not close hearing. Okay. Okay. Computer guys, I need your eye contact. Computer guys, I need your eye contact. Computer guys, who am I?
Your boss.
Decision making body.
I'm a decision maker. I'm a decision maker. A defense is here. I gave you decision maker. I gave you notice. I gave you discovery. I gave you delay. Now is hearing issue. I provide you right to cross-examine, right to counsel, admissibility of evidence, and hearing is open. If I'm gonna say, ma'am, you know what, ma'am, hearing is going on for 5 minutes. Can you please step out from the room because I have to talk in privately. Why hearing is not open? Serious procedure, fairness, right? Okay, now, okay, okay, 25 marks question gonna come from bias. 25% question 25 marks gonna come from bias. How bias gonna start in the hearing? Okay, while hearing, I can be a bias. How can be a bias? For example, once you're gonna start me questioning, hey, you people are burden of this country. You people are burden of this country. There was a wording in Dunsmuir. Baker and Dunsmuir is a two leading case. What happened in Dunsmuir? There was a deputation order. There was a deputation order. In a hearing can be oral, hearing can be paper. In the paper hearing, he had written the words, you, in a bold word, you people are burden. She was from Jamaica. You decision maker, they provide notice to Miss Baker, right? Baker, no, Dunsmuir. Notice, discovery, delay, but in hearing, instead of oral hearing, they provide paper hearing. In the paper hearing, he has written the comments in the paper hearing. You people are burden of this country, which is a bias, antagonism. Do not write. Bias do not write. Bias is a separate question, but bias would be from the hearing, whether hearing would be oral or written hearing. I'll let you know later. So I have fulfilled my requirement just to procedural fairness. Bias also would be. Your eyes are very red. Yeah. Yeah, your eyes are very red. Okay, so I have fulfilled. Then, okay, ma'am, you know what? Hearing is done. So we're gonna inform our decision next weekend. Next weekend, you open the envelope, reading a decision, you are fired from the job. Now you are fired from the job. Exam would start once you will take a final decision. Once you are gonna open the envelope, you are fired from the job. There was a deputation order. Exam exact after the long facts, 3, 4, 5, 6 pages facts. At the end, when you open the envelope, okay, at the end, decision was against you. Now you are very unhappy with the decision. You approach to the articling student, which you are articling student in the law firm. You have to write a memorandum for this nice lady. Start writing, right? Start writing. So computer guys, now actual exam would start. First was facts. First are all are facts. You got it? Facts. After the facts, you are very upset. Okay. Final decision. Okay, post hearing issue, duty to give reason. Write it down. Duty to give reason. Reason has to be a sufficient. Not you are fired from the job. Proper reason. I need a proper reason, man. I need a proper reason. Computer guys, I need your eye contact. So there are two parts of admin law. One is substantive. Okay. Now we have to start procedure. The second is admin body, private body. Admin body must follow the proper procedure. If private body, they will not gonna follow the proper procedure, even procedure. Number 2. Number 3, what procedure? Pre-hearing issue, hearing issue, post-hearing issue. What pre-hearing issue? I gave you notice, I gave you discovery, I gave you sufficient time, which is called delay. Sufficient time between the notice and the hearing. If there is not a sufficient time, violation of procedural fairness. Violation of procedural fairness. But I have to provide you. But in an exam, maybe they will not, they're going to give you notice, they're going to give you discovery, tomorrow is a hearing. Pick up that issue. Oh, there was a violation. Pick up that issue. Then I provide you right to counsel, right to cross-examine, hearing is open, admissibility of evidence, and open hearing. Hearing was open. Okay. Then post-hearing issue. When you open the envelope, you are fired from the job. There should be a sufficient reason. So you will see in exam. Okay. In one line. Okay. You know what? Okay. We would not provide you long. Okay. You will see in exam. Okay. You know what? You are fired from the job. This is sufficient. Oh, you are fired from the job. No. I need a proper. I'll explain you. This is my first class. How I'm going to explain in my first class. Is 300 pages book. I have only procedure is done. Whole pages are procedure is right here. That's it. That's it. You're going to take in my exam. Procedure and substantive 4 pages. I don't know where is the third page. There are 4 pages. 4 pages for substantive. 5, 6, 7, 8 pages for whole admin law is done. You are my witness. Your friend appear in January. Admin law. She did it, right? So only these pages, right? That's it. She is my witness. Her. Okay. Anyway. Okay. Now start writing. Now, computer guys, I need your eye contact. Now you are very upset. You are unhappy with the decision of the admin body. Admin body was, let's say, a hospital. Okay. Hospital board. Medical association board. Okay. Now, okay. Now you're going to go to the court against the decision of the admin body. Okay. Now you're going to start writing. Okay. Whenever you're going to go to the court, there are 3 more room. There are 3 more room. We have to write in exam. There are 3 more room. There are 3 more room we have to write. Okay. Exam would start, exact exam would start from this point of view. First step is okay. After the given scenario, what is a given scenario? Notice, discovery. Okay. You know what? I'm sitting in an exam. Exam would start by 9 o'clock. I'm waiting for 9 o'clock. Now is 8:59. 9 o'clock. Open your envelope. Start exam. Exam is start. Oh, notice requirement met. Discovery requirement met. Or delay. Or next day is a hearing. Highlight. Oh, one issue I pick up. Hearing. He was a bias. Hearing. Right to counsel is not provided. Highlighted. Oh, right to counsel. I have to mention. Okay, right to counsel highlighted. Okay, hearing is open. Everything is good. But decision maker is biased in hearing. Highlighted. Okay. Hearing is done. You will read. Oh, hearing is done. After the hearing you received. Okay, you are fired from the job. This is sufficient reason. Only in one line. Okay. It means, after reading all questions, now start writing. How we gonna start writing? How we gonna start writing? I need your eye contact. Do not write. Do not write. I need your eye contact. ये मैं demonstration कर रहा हूँ. इतनी अच्छी तो शाहरुख खान भी नहीं करता होगा. Start writing. Start writing. Judicial review. Okay. When assessing an application for judicial review, first 5 questions I have to met. First 5 questions. Before I'm gonna go for judicial review, I have to met 5 preliminary questions. What are the 5 preliminary questions?